Good afternoon, everybody. My name is Haysam Amin. I go by Sam. I'm an attorney here in San Francisco, California. Today we will be discussing the Ninth Circuit Court of Appeals decision to strike down California's ban on high-capacity magazines. Before we do that, I'd like to invite you, if you haven't already done so, to please subscribe, like, and comment. If you have any specific questions, of course, you can always direct message me. I'd like to also invite you to follow me on my other social media platforms, Facebook, Instagram, TikTok. Now, back to the Ninth Circuit Court of Appeals decision to nullify or strike down California Penal Code 32310, which prohibited being in possession, manufacturing, transportation, etc. of large capacity magazines, anything that exceeded 10 bullets. The Ninth Circuit Court of Appeals noted in its argument that although the law was well intended and it was meant to address mass shootings in California, it violated the Second Amendment right to bear arms. And in essence, the law, the California ban of high-capacity magazines, designated, or rather made the possession of any high-capacity magazine that's that's more than 10 bullets, either a felony or a misdemeanor. And by the court's calculation, that's almost half of the weapons that are currently being sold in the United States. Now, opponents of the decision argue that the judge who wrote the decision, handed down the decision, is a Trump appointee, and that a ordinary citizen does not need a high-capacity magazine to defend his or herself. The opponent further argued that the Second Amendment never intended to provide the ordinary citizen with warlike weapons, such as high-capacity rifles. Now, depending on how you fall in the spectrum, whether or not you support this decision, a lot of folks here in California, specifically defense attorneys and their clients, champion this decision because it makes a lot of the pending felony or misdemeanor cases now susceptible to dismissals, essentially. And although the California Attorney General has yet to make a decision on whether or not he is going to appeal the Ninth Circuit Court of Appeals decision, it appears that there's a loophole, or rather a time frame, by which defense attorneys and their clients can take advantage of the Ninth Circuit Court of Appeals decision to strike down Penal Code 32310. Now, I have a specific case here in San Francisco where my client was caught with a gun and high-capacity magazine. Now, my client now stands to benefit from this decision that was recently handed down from the Ninth Circuit Court of Appeals. And my client now goes from facing prison time or even jail time to potentially flat-out dismissal. And it would benefit somebody who has immigration consequences, for example, or someone that's a lawful possession of a gun, but maybe not a lawful possession of a magazine. And that's a classic example that always happens. And I'll give you one right now. If you go to a gun show cross-state, Arizona, Texas, Oregon, and you decide to buy a magazine that holds, let's just say, 12 bullets or more, and you bring it back into California, you are now, or rather, it used to be a felony or a misdemeanor. Although you can be lawfully in possession of the gun, the magazine is a separate offense, and it could cause a whole host of problems before the Ninth Circuit Court of Appeals decision to strike down the law that is, in essence, a violation of the Second Amendment pursuant to the Ninth Circuit Court of Appeals decision. If you enjoyed this video, I'd like to invite you again to please subscribe, like, comment, share. If you have any specific questions, I'm happy to address them either in direct message or at my next video. Also, again, please subscribe to my other platforms, my social media platforms, TikTok, Instagram, Facebook. Thank you for spending a few minutes with me. Have a good day.
Being the only person that's advocating in the courtroom on behalf of the accused is a humbling feeling for me. I believe in the tenets of the Constitution, which is innocent until proven guilty, and that carries from day one until the trial date.